Thank you, Mr. Chairman. And I might note for Mr. King that of the 5 justices in the majority on last week's opinion, 3 of them were appointed by Republican presidents. Mr. Wilkerson, I would like to ask you a couple of questions just about if you can comment on some things that you have said recently for clarification. Recently, you were quoted as stating, Haynes, Fife, you, Bybee, Gonzalez, and at the Apex, Addington, should never travel outside the U.S. You continued, they broke the law, they violated their professional ethics code. In future, some government may build the case necessary to prosecute them in a foreign court or in an international court. Why do you describe Mr. Addington as at the apex of this group, and what prompted you to make that statement?
Because it's my view that Mr. Addington's very astute brain was integral to the development of not just the legal position to back the CIA's findings program, but also to back ultimately the program that DOD generated for the armed forces.
In terms of the legal memoranda that was written by John Yoo, did you ever see Department of those memoranda, and what was your reaction?
I saw some of them. I didn't see all of them. In fact, as I listened to Senator Levin yesterday, I was stunned. I knew Senator Levin was sitting on a lot of material that I had not seen, but that I'd heard of, but I had no idea he'd gotten almost all of it, apparently, with a few exceptions. The memos that I saw gave me the impression that lawyers were sitting in a room, you'll pardon my soldier's view of this, trying to count how many angels could sit on the head of a pin with regard to something that was, to me as a soldier, quite serious: torture, abuse, and so forth.
That leads me to ask you about some notes that were released from a meeting in Guantanamo Bay in October of 2002 that was reviewed yesterday in the Senate Armed Services Committee about interrogation methods. In that meeting, a CIA lawyer named John Fredman described the legal guidance that the CIA had received from the Department of Justice. Mr. Fredman said that according to the Justice Department, whether something is torture is basically subject to perception. And he also wrote, if the detainee dies, then you're doing it wrong. In terms of demonstrating that rules for covert operations eventually spilled over in standard military procedures, can you describe your discomfort, I guess it's probably an understatement, between the significant difference between Army field manual procedures and CIA intelligence gathering techniques, and where your discomfort lied?
Right.
Okay.
I have some familiarity with what some of the CIA teams did in Vietnam, for example, that the military took, at least the military I was a part of, took some great umbrage at. So I do have some historical familiarity with what the CIA can do in the field, has done in the field, as opposed to what the military can do in the field. In this case, I think there was this double effort. The CIA would do a highly classified, compartmented program that would, as was pointed out earlier, only affect high-value targets, and they could do certain things against those high-value targets. I think what happened on the other side of the river, so to speak, was that the Pentagon wanted to wage this conflict on a very wide-scale basis. They wanted to go after everyone from Abu Sayyaf in the Philippines to Jamaat Islamiyah to Al-Qaeda, every terrorist that could possibly come against us. Mr. Feith writes about this quite extensively in his book, War and Decision. And as a consequence, they needed actionable intelligence too. They immediately put the Special Operations Command into the mix here, so much so that we actually had ambassadors calling in from the field at the State Department and saying to the Secretary, who are these 6'4", 19-inch bicep male Caucasians walking around in our capital, known to everyone? Of course, the ambassador knew exactly who they were, and we had to ask Mr. Rumsfeld what's going on. And he had to eventually fess up that he was putting these people in capital cities around the world and other places. So they needed actionable intelligence for these people to take direct action or to kill terrorists in their areas. And that's what caused, I think, the gravitation over to DOD of the legal philosophy that backed the CIA program and some of the same techniques that Secretary Rumsfeld admittedly very painstakingly went through and tried to identify those that would not constitute torture but would bring results. And then
as my time expires, so basically, is it your opinion that DOJ crafted legal advice really intended for the CIA so that it would be applicable and utilized by the military in intelligence and interrogation gathering techniques?
I don't know if that was Justice's intent, but I know that's what I'm 99% sure that's what happened.
And whether it was intentional or not, it's still illegal.
That's what we're arguing about.
I yield the balance of my time.
I thank the gentlelady. I now recognize for 5 minutes for the purpose of questioning the witnesses the gentleman from Minnesota.